I cannot possibly be the only one that thinks this story poses serious cause for concern. So at any point you feel you agree with me, please feel free to comment in the box below that you agree, or indeed if you disagree with what I think about this story. But I, for one, think that there is serious cause for concern. So His Majesty's Inspectorate of Constabulary, Mr. Parr, has said that there is at least anecdotal evidence that some applicants to the Metropolitan Police were being accepted even though that they were functionally illiterate in English and had difficulty writing up crime reports. Now, just to be clear, anecdotal meaning it may or may not be true, but there is some kind of evidence that suggests that there is a correlation or causation between those applicants being functionally illiterate in English, meaning they cannot properly read and or write and have difficulty in writing up crime reports. Now, this appears to have all been driven by a side story, which is quite rightly the Metropolitan trying to be more diverse in its policing staff to represent the community of London. That, I think, is absolutely right. I don't disagree with. But as Mr. Parr himself has said, this cannot be at the cost of lowering standards. Now, I'll give you the reasoning behind my cause for concern about this, and you can obviously let me know what you think, whether you agree or disagree in the comment section below. Now, one of the reasons that prosecutions often fail, and bearing in mind this is by the time it's got to court, it's usually a fairly serious offence, but there might be some very simple aspect of it that simply makes the case fall apart. And remembering that any kind of prosecution is to a criminal standard which is beyond a reasonable doubt, also that the modern phraseology for a jury to understand it is so that the jury must be sure that a thing happened or didn't happen. For example, in the case of self-defense, that the jury must be convinced by the prosecutor that they are sure that they were not acting in self-defense. It's never the defense that have to prove beyond a reasonable doubt. The defense never have to prove that beyond a reasonable doubt. It's only on the balance of probabilities at best, or raising an evidential burden. The prosecutor must prove that. However, the point of all that is this. The prosecutor has essentially the more difficult job. Why, you ask? Well, because if we're going to punish somebody for something, we'd better be right. So that's the relevant standard. We need to prove the case beyond a reasonable doubt so that the jury is sure. Or if we as barristers are defending, we raise sufficient doubt so that it may not have been this particular defendant, or it may not have happened, or they may not have intended it, or it may not have been the case. It just may not be what the prosecutor says it is. Now, that's important because let's take, for example, a case of possession of drugs, perhaps with possession with intent to supply. Very serious offence because this is within the criminal chain network, and supplying of illicit substances clearly fuels the whole crime network around the country and is resultant in lots of ongoing and snowballing effects. So quite rightly, that is a serious offence and is tried properly, severely, and there are of course hefty punishments once convicted. However, that doesn't mean that the standards are lowered for the prosecution because it's a serious offence and quite rightly they should be convicted. Quite the reverse. In fact, the more serious an offence, the higher that standard tends to be, albeit it is a certain threshold beyond a reasonable doubt. But if you are convicting somebody of something very serious, then that is a very high standard. So then we look at the chain of custody of said substance. So taking a very simplistic example, a person is arrested in the streets containing a bag with substances, with cash and so on, and are accused, charged and prosecuted for possession with intent to supply of a controlled substance. Now, if that officer, the arresting officer of that defendant, takes the bag, then the officer has that within their possession. Police officers naturally have a specific legal defence for being in possession because they need to take possession because they've arrested the defendant or the suspect at that point and taken those substances off them. First of all, the officer is not and cannot be certain as to what that substance is. It may be a white powder, but the police officer clearly will not know for certain what that substance is, or if it is a particular substance, what percentage are within those substances. So the police officer needs to get that tested. But before that happens, the officer obviously has to take the defendant back to the police custody. They get booked in and they go into the custody suite, and the police officer then books the substance, whatever the substance is, described as a white powder, much like something that may well be gold is described as a yellow or a white metal object, and potentially gold or whatever, but until it's proven, the officer doesn't know what it is. Same with the white powder. So the officer then books that into evidence. But one example of where a case like this has fallen down because of a simple routine error. Now, the officer intending to book this substance into the evidence room, the evidence locker, they have a computer outside this room to book in this substance. They put it in an evidence bag. It is sealed. There is a number on it, and this starts the very next stage in the chain of possession of said substance. Now, you remember that is in the possession of the officer, so the officer will make a record to say, I took this from the suspect, I had it in my possession until I booked it into the evidence room, the evidence locker. Now, when getting to that, this is a real story, when getting to that book-in computer, it was already logged in as somebody else. So that officer, instead of logging out and logging back in because the officer was short of time, the officer simply booked it in under somebody else's collar number. Now, you can possibly guess what happened. Type in the comments what you think happened next to this whole case and why it fell apart. But that officer booked it in under someone else's collar number. They did all the usual stuff in a bag, sealed evidence bag with a reference number on it. That's going to be the same evidence number all the way through. It's supposed to go off to a lab. They'll get it tested. They get it confirmed as to what the substance is. It gets sent back as and when necessary. And ultimately, a year or two later, or 3 or 4 later, ends up in court in an evidence bag. And they say, this is what we took off this suspect. It was confirmed by XYZ specialist checks that this exactly was the substance. One of these cases has fallen apart because, as you've guessed it, it was booked in under somebody else's collar number. Now, because it was booked in under someone else's collar number, the line of cross-examination against the officer went as follows. You cannot be absolutely 100% certain that this was the same substance because it was booked in under someone else's collar number. If it were the case, as it was in this case, that officer has also booked in something of a similar type of substance on the same day, around about the same time, which was, I suspect, the reason they were logged into the computer in the first place, you cannot be 100% certain that your bag was not switched with his, and therefore it is not the same bag. Therefore, if the other bag turned out not to be this substance, you cannot be 100% certain. Therefore, the chain of custody of that substance was broken. Therefore, it is not right to convict this defendant on a broken chain of custody because you cannot be certain of what this substance was. So that case fell apart. Hundreds, if not thousands of hours of work by the CPS, by the police, by all sorts of people that have taken part in the prosecution, not to mention the lawyers and the court and the jury and the judge and everything else, all to get to this point in the case where it falls apart. It fell apart in court because there was a break in the chain of causation, and that case obviously was not a successful prosecution, whereas otherwise, I dare say, it probably would have been. So, coming back to the point where in order to achieve what is quoted to be ambitious targets, the anecdotal evidence is that candidates that do not meet the minimum criteria to join the police force, which the last time I checked is a minimum of the equivalent of 2 A-levels, are being accepted whilst they are in fact or at least there is anecdotal evidence to suggest that they are, in fact, functionally illiterate in English and had difficulty writing up crime reports. Now, whilst my practice isn't predominantly criminal work, I have done criminal work, but my primary practice is not criminal work. All barristers can do criminal work when they leave bar school, but most barristers do specialise in one or another. Whilst mine isn't specialist in criminal prosecutions or defense, I would certainly take a case like this, and if there was a badly written up crime report, it would be relatively easy to tear down and cross-examine on a crime report which is inconsistent, incoherent, simply doesn't make sense, or falls down on any one of the items such as those that I've mentioned, because they have to be absolutely crystal clear, without any errors, without a doubt, all the way through, that defense counsel can pick apart and make a case fall apart. Now, the evidential gathering stage, which is what ultimately the police are responsible for, is absolutely crucial. So replace this kind of crime with some kind of substance with a more heinous, a really serious crime against the person, and imagine the victims and the victim's family and everyone surrounding that crime. Imagine that they fall down on one crime report that was badly written or just incoherent because one officer was accepted because they were functionally illiterate, as it was put by Mr. Parr, according to anecdotal evidence. Anecdotal, and again, being that which may or may not be true, but there's a suggestion that that might be the case. So I invite your comment in the comment section below. What do you think of this sort of practice of taking in officers that don't necessarily meet the minimum criteria to fulfill targets, which are obviously appropriate targets to meet the diversity targets for the force, but as Mr. Parr said, it should not be at the risk of standards, and it should not be lowering standards to do so. So as I say, let me know what you think in the comment section below, and make sure you hit that like button and subscribe, and I will bring you more interesting stories as I come across them. In the meantime, thank you all so much for watching.